So welcome everyone. Today we're going to be talking about capacity to manage finances and the legal complexities around capacity to manage finances with a deputyship versus a lasting power of attorney. And the first talk is going to be Dr. Alana Tees, who I think most of you know from Arbor, and Jess are going to be talking about that in the first talk. And then the second talk, we're going to have some of the Arbor multidisciplinary team talking about the practical ways of helping clients, vulnerable clients, to be autonomous and to regain capacity or gain capacity to make decisions about their finances. So over to you guys.
Very much. Okay. So, thank you for that introduction. Now we're going to go on to talk about the law on financial capacity and deputyships versus lasting power of attorney. And then after lunch, there's going to be the MDT talking through how we support clients through both assessment and neuro rehab. Okay, so in this talk, we're going to start off with the law on granting LPA. Then think about what is the guidance and expectation for attorneys. Then looking at how you would assess financial capacity, the case law on this, and then the key question that inspired this whole day, is it possible to grant lasting power of attorney if you don't have financial capacity? And I have this discussion with many solicitors on a fairly regular basis, and we'll come into specific examples on this later on. The effects of a personal injury settlement on both types of assessment, and then finally an update on digital lasting powers of attorney. Okay, so in 2022, Mr. Justice Poole very helpfully outlined the stipulations of what somebody needs to be able to understand, remember, weigh up and decide upon in order to have capacity to grant power of attorney. And he said that someone should understand the effect of the lasting power of attorney, who the attorneys are, the scope of the attorney's powers, and that the MCA restricts the exercise of those powers, when the attorneys can exercise those powers, including the need for the LPA to be executed, so sent off to the Office of the Public Guardian, found to be correctly filled out and sent back before it's effective, the scope of the assets the attorneys can deal with under the LPA, the power that the donor has to revoke the LPA if they still have capacity to do so. So that's very important for people with, say, degenerative conditions, that later on you may have lost that capacity to revoke the LPA. So that's something for that group to bear in mind. I mean, that can affect anyone, but particularly you might expect it to affect people with conditions that are getting worse over time. And finally, the pros and cons of executing the particular LPA and of not doing so. And so I've highlighted some of these because we're going to be talking further about those later on. So B, E and G, we're going to circle back to considering clients with personal injury settlements, and we'll also discuss how to support someone with speech and or language difficulties this afternoon. Okay, so the person needs to consider, who do you want as an attorney and why? Do you understand the scope of your assets that the attorney can manage under a lasting power of attorney? That's important and can change after a settlement. What are the risks? So do you trust your proposed attorney? What evidence do you have of their financial capabilities to manage their own finances as well as yours? And most importantly, sometimes, is the person fully aware that LPAs are not monitored in the same way that a deputyship is? That quite often it might be the case that if thousands of pounds were suddenly taken out of their bank account, that might flag up, the bank might flag that if it was above a certain threshold. But if it's £20 here, £50 there, probably no one's going to notice and no one's going to check, and it is not monitored like a deputyship is. So that's really important for me to highlight to clients that I'm working with in these assessments. Notably, Judge Lush, who we'll come on to because he did some very good case law for us all to look at later, he said in an interview he'd done with a newspaper that he would never get a lasting power of attorney because of the scope of those powers. And of course, all of the cases he has seen in court, I would think, might have skewed his impression towards what can go wrong. Personally, having worked in the NHS for many years, I've seen the flip side of that coin, which is when you are under just social services, how challenging that can be. Met some excellent social workers, but there can be a backlog for getting assigned that can hold things up. Trying to get under the client affairs department for them to be an appointee or even go for deputyship, that can take so long and can be an ongoing challenge. And all of that can sometimes delay discharge for somebody that's desperate to get out of hospital, which I've seen before as well. So it's interesting how the different experience I've had that Judge Lush has had has skewed our perception of lasting power of attorneys. Okay, so now, Jess, I think you're speaking on expectations of attorneys.
Hi, everybody. So it's important that if someone is being appointed as an attorney, they understand what the expectations are, because they are going to have various duties and responsibilities. So there is obviously the very detailed code of conduct to the Mental Capacity Act that sets out a lot of information, very long. I don't think many attorneys actually read it, unfortunately, but it has got some really good detailed guidance. So some of the responsibilities and duties that attorneys need to be aware of would be, first of all, a duty of care and skill. So does the attorney have the relevant skills to carry out their role? And then they have a fiduciary duty. So the attorneys must manage the client's money with due care, must not take advantage of that position. They must not profit or benefit from that position. And also they must not allow any personal interest to conflict with their role as attorney. Attorneys also have a duty of good faith. So they have to act with honesty and integrity. They have a duty of confidentiality and duty to keep full accounts, just in case these are ever requested by the Office of the Public Guardian or the Court of Protection. When the Capacity Act was first enacted, there were sort of threats that might happen as a spot check, but I don't know if I've never seen it. I don't know if you have. So it's probably more if a complaint is made against an attorney, and there's a case that I'm going to mention shortly of Senior Judge Lush, which is quite an interesting one. And also there's the duty to make sure that the attorney keeps the donor's money and property separate from their own finances and or other people. So the Buckley case, this is an oldie but a goodie. This was a case from 2013, and it's got some really good commentary on duties of an attorney under a lasting power of attorney, particularly in respect to fiduciary obligations. So Miss Buckley was a resident of a nursing home, and in 2010 she appointed her niece as sole attorney. In 2012, the Office of the Public Guardian received a complaint about how the niece was managing Miss Buckley's finances, and they opened a formal investigation. The attorney was found to have breached her fiduciary duties by using Miss Buckley's funds for her own benefit. So she'd invested in a reptile breeding business, and that was deemed to be an inappropriate and unauthorised use of her aunt's funds. So in Senior Judge Lush's ruling, he emphasised that obviously an attorney must first of all act in the donor's best interests, avoid personal conflicts of interest, and there is a standard of care that is required of an attorney when carrying out their role. which the niece was found to have breached. There's also some very helpful guidance in this case that sets out the different levels of funds that the donor might have and what might be appropriate for an attorney to invest in. So Senior Judge Lush had said that attorneys have fiduciary duties similar to a trustee, and they should comply with the standard investment criteria, which is set out by Section 4 of the Trustee Act 2000. So there is a requirement to obtain proper advice, to keep the donor's funds in their own name and separate from anybody else's. So as I said, the code of practice is really quite helpful for attorneys. Yes, it's very lengthy, but it's certainly worth looking because there is some really good guidance in there. And just in the Buckley case, the LPA was actually revoked, so the niece could no longer act, and then a Court of Protection panel deputy was appointed instead. Okay, so next case actually relates to deputies. So obviously with deputies, they're having to do the annual reports. So this was flagged up a lot quicker because of the annual reports. So in the case of ReGM, this is another Judge Lush case. He considered the scope of powers that an attorney and deputy has. So in this case, niece and great niece were appointed as deputies for property and financial affairs in August 2010. They then applied to the court for retrospective consent for gifts that they had made to themselves as deputies and to get authorisation for future gifting. So the retrospective application was found to amount to just over £230,000 in outright gifts. And they also were claiming expenses of over £46,000. This is 1 year acting as deputy. The expenses included purchases of cars for the deputies, designer handbags, watches, and horse racing tickets. So we get some quite wild cases. The appointment of the deputies was revoked, and a panel deputy was appointed. So this was another clear example where the deputies are basically acted in their own interests. They weren't considering the interests of the donor. And that's on I think.
So coming on to thinking now about finances, the link here is a really good document that I use very regularly to refer back to. This was a lot of well-known people in the field who came together to put together quite a long document that helps to think about, it's for empowerment matters. It's about assessing capacity for financial decisions, and it's a guidance document. And although it's now over 10 years old, it's still the best that I've come across to refer back to. And what it really highlights to me is when you have these longitudinal decisions, which unlike LPA, which is a single point in time decision, finances is ongoing, it's every day, it's longitudinal. So there's a few things like that. So sometimes managing long-term health conditions will be longitudinal, like diabetes, finances, and capacity to litigate, where you have an ongoing back and forth with your solicitor over what instructions you wish to give as the situation evolves. And the importance of that is that, unlike, for example, making decisions about your care, where, for example, let's say you need help with washing and dressing, and you are realistic about that, you know what help you need, what could go wrong if you don't have that help, and say who you can complain to if you're not happy with the help. What we don't require is for people to actually be able to do it themselves, to have capacity. What they need to be able to know is what help they need. Now, with finances, you can have an awareness that, say, you have aphasia and you can't talk on the phone, or you have working memory difficulties and it's difficult for you to hold different bits of information in mind whilst you're deciding on it. That awareness does not give you capacity, because you also have to have the capability. washing and dressing is pretty standard for all of us. You know, there's differences. Some people like a shower, some people like a bath, some people like a strip wash. But generally, it's a fairly standardized activity. Once you get to finances, it's not possible for somebody else to always present the information to you, because your values might be different to theirs. Are you a spender? Are you a saver? You know, thinking about also micro decisions that you make today. Shall I buy these tickets or whatever, and to the horse races? Maybe you want to do that yourself. You've also got to think about the long-term plans. If you're doing that every day, what's that going to mean for paying your bills? And you know, somebody else can put forward logical choices, but what somebody else decides is wise versus unwise is a matter of personal values and what you consider important. So actually, when it comes to finances, capability does come into play, whether the person is able to do certain things themselves to manage their finances. And even if they have awareness of their difficulties, it doesn't necessarily mean that that translates to having a financial capacity. Okay, so this was from an OT document many years ago that I cannot find again. I would love to reference it and give them credit. If anyone else can find it, do send it. This was some suggestions of the various levels of finances that I've been using ever since. Sometimes for individual clients, it can be more individualized, of course, but this is my starting point that I consider when thinking about finances. Everything from, do they understand the math? Can they recognize coins and notes? Do they understand the different values of coins and notes and how those add up? Then going on to everyday things like being able to shop or budget for a meal, through to weekly budgeting, bill paying, monthly budgeting, managing accounts, saving for larger expenses, and then if you've got a personal injury settlement, looking at long-term investments such as managing pensions, savings, personal injury settlements, and then a very important one, financial vulnerability and awareness of risks. And for our client group, that can sometimes be risk from themselves as opposed to risks from others as well. So someone who knows they're a little bit impulsive, they may tell me, if I had full control of my money, I'd probably just go and, you know, buy a Maserati or something. And I say, but you don't have a driving license. And they say, I know, and I'd probably do it anyway. And then be like, what am I going to do with this? So the good thing about our client group is quite often they just tell you the truth. And I'll just write that down. Thanks very much. That makes my assessment easy. Okay, I have on purpose left this highlighted in green because it's the key point that I bring up every time the argument comes up of, oh, how could somebody grant LPA if they don't have capacity for finances? This is, again, Senior Justice Lush, who's done so many of these cases that I begin to think no wonder he doesn't want an LPA when he's seen it go wrong so many times. So this was in the matter of Collis right back in 2010. So the relevant case of LPA is Mr. Justice Poole from 2022, but this is still important background to the possibility that somebody maybe could grant an LPA even if they can't manage their finances. And again, that insight is very important when you're making that distinction. Senior Justice Lush said mental capacity is issue specific. That means that the capacity required to create an LPA is not the same as the capacity to manage one's property and financial affairs generally. And I have quoted this in my reports before, where it's been this distinction, usually around capabilities when it comes to finances. So it's not the same as financial affairs generally, or the capacity to make a will or a gift or a loan. And then he goes on to talk about other things like medical treatment and care, which I've mentioned. Oh, I'll skip one there. Capacity is also time specific. So focusing on the particular time when a decision is made or has to be made, and that after just a few minutes or on the following day, if a person cannot recall having made a particular decision, it doesn't automatically mean that he or she lacked the capacity to make that decision or that the decision is invalid. And that's very important for LPA assessments because I work with a lot of people with quite significant memory problems. And if you use all of the scaffolding and the help to help them in the assessment to make that decision, which we'll be talking more about this afternoon, that person very well might be able to capacitously make a decision, document everything. This is the help I gave. This is what they said. This was the result. And then the next day they might have forgotten that, you know, Jess came in and that we all did an assessment together, or a lady came. What did we talk about? That doesn't mean that they don't have capacity. It just means they have significant amnesia, and one does not negate the other. Okay, so looking at some more case law thinking now to do with finances again. So Mark Headley, this was an excellent judgment in terms of all of the things that can be mined from it, not just in the specific case, but across capacity case law. So he defines the capacity to manage one's own finances as a longitudinal decision, in contrast with isolated decisions, for example, making a will or power of attorney. So again, backing up that these are different and separate. They can overlap, which we'll come on to, but they can also be quite separate. The assessment of capacity to make longitudinal decisions places a greater emphasis on capability, and again left that in green because that's the key word there, to undertake the management of finances, and that each decision impacts other future decisions, not just isolated micro decisions. So as I said, yeah, you can buy tickets to the races yourself, but if you're doing that every day and then you don't have money to pay your bills, or to buy food, that's going to be a problem. But on that one day, you might be okay to make that decision to do this one-off thing. Okay, so now thinking about what happens when somebody has a personal injury settlement. So for both the capacity to grant lasting power of attorney and financial capacity, there is a sudden change in peer group and assessment questions. So normally, across all capacity assessments, assessment should be done on the balance of probabilities and to the level of the average person in the street. There is, guidance and case law on not over assessing, that people don't need every minute detail. And there's plenty of 2013 cases that was around hospital discharges and care and residence where that came up and was highlighted by the judge. But now for a person who has a personal injury settlement, which can be millions of pounds, the average person for their peer group has changed. I was having a think about who is similar, that has not had a personal injury settlement or an injury. And now the person has to choose financial advisors, understand risk profiles of investments, thinking about long-term financial management, etc. And they're often in a position where they cannot earn more money if they're not able to work to replace money lost through any unwise decisions or decisions that have turned out to be poor and gone badly for them. So people who are earning a lot of money and continue to earn a lot of money might be able to, let's gamble on a new crypto coin, and it might go quite badly, and they then have the capability of earning more money to still pay their bills. But when I'm thinking about who the peer group is for this client group, the only people I can think of would be, say, somebody who's 65, who's retired with a large pot of money. They're not able to go back to work, and that money has to last 20, 30 years even. And they're probably at some point going to be paying for care. So your peer group, compared to the whole of the working age general public, has suddenly shrunk to a very small group of people that you could compare to. And even then, a 25-year-old with personal injury assessment is not a 65-year-old just looking at their retirement. So even then, it doesn't quite translate. So there is a high level of risk questions in my assessments for both LPA and finances. So thinking now about the question, is it possible to have capacity for one but not the other? I think we've answered that in the law, but what does that look like? So I find that it's not common when a client has a personal injury settlement because of the high level of risk questions. So I find it more common in a hospital setting where there's not a personal injury, issue where somebody wants to grant LPA, sometimes so that their relatives can access their funds to help them get out of hospital. So if there's a barrier and they need to be, say, paying for care going forward, and they're looking at different discharge locations, maybe they want to go to a nice care home that's quite a bit more expensive than what social services will pay for, even for the first 6 weeks, but they can't access their funds because they don't have capability, but they know exactly what they want and they do trust their relatives, and their, you know, son is or daughter's an accountant, and or no issues there. And that might be a case that I would see quite commonly, where somebody could grant LPA but hasn't yet recovered enough to manage those finances and do all of that themselves from, you know, their hospital bed whilst they're trying to engage in rehab. So I usually find that it's lasting power of attorney but not finances. If it was the other way around, it would be, I think, more the case that somebody doesn't have a person that they trust to grant LPA to. So it's usually an issue with that capability. The person must still be able to have the ability to learn new information. This can be a challenge. We'll talk more about how we address that this afternoon. But if the person can learn the new information, then a lot of the LPA stuff, some of it is about their individual circumstances, but some of it is, what is the power an LPA gives? What do the rules do the person have to follow? What do I do if I'm not happy? Can I revoke it? All of that can be learned. Usually, if the donor has a close, long-standing, trusting relationship with somebody with good financial capabilities and no financial related criminal record, hopefully. So, for example, if they have, say, an adult child who's very good with the finances and who they trust, maybe even helps them already manage their finances just informally, then that would be that's always bonus points, because the person's already demonstrated that they will help the person and haven't stolen their money in the past. So that always helps. And also just to note that if you are certificate providing, even if the person is demonstrating capacity, if you have a safeguarding concern, I'm not signing that LPA. I'm not certificate provider. I'm not putting my signature on anything that I'm not happy with. Me not being happy could be a safeguarding issue rather than a capacity issue. So the person might say, yes, I'm aware they've got a criminal record for fraud, but they wouldn't do that to me. I'm not signing that. Find someone else. I'm not doing that. So just be aware that as a potential certificate provider, you're not obliged to sign things that cause you a great deal of concern, or in fact any concern. Or you can also ask for something to be investigated before you're happy to do it. So it's not just about capacity for that. Okay, and now Jess can finish off talking a little bit about digital LPAs. Got one more case example at the end we'll come back to.
So you will have heard about the digital LPA system that is being dealt with by the Office of the Public Guardian. So it is going to streamline the process and make LPAs a lot easier to do and be registered in the future. So there are a lot of pros to what the OPD are looking to do. You know, from a practice level, they are absolutely overwhelmed with the amount of applications, the amount of paperwork they have to deal with, and it will be really helpful for some people. However, for a lot of the clients that people in this room deal with, it's, you know, there are some concerns. So myself and a colleague went to the OPG in London to look at some of the processes that they're putting in place together with some other professionals, and we asked questions of, you know, the process they're setting up. They're going to be obviously they will do checks on the donor, the attorney. However, they're not responsible for whether or not the donor has capacity. So it will be very helpful for some people, but we are concerned about the risks for vulnerable clients. Now, just circling back to the duties that we talked about at the outset that an attorney has, if somebody's basically doing an LPA digitally with perhaps a family member or a friend, they're not going to be getting the advice from the relevant professionals about who should be their attorneys, what kind of skills do their attorneys need, what is their capacity. There's lots of things that, you know, vulnerable clients would just miss in that process if someone is doing a digital LPA for them. So we are concerned that it is going to be subject to abuse. Obviously, the OPG can't be responsible for that from the outset. And as I said, they will need, the donor and attorneys will need to verify their identities, but there's no sort of second check. So we are still impressing the need to get proper professional advice and a proper capacity assessment in order for the LPAs to be drafted in the right way. There might be powers that need to be included that a family member or a friend just wouldn't know to include. So I think it is, the digital LPAs will be really helpful, and hopefully it will streamline things with the OPG. But there are still lots of things to consider around, drafting of those documents, capacity, who is the right attorney. And then just a final point on multiple powers of attorney. So we do often see this. Initially, it might be that if a client is needing an LPA for property and financial affairs, they might have one set of attorneys to deal with their personal affairs. If they have business interests, for example, they might need separate attorneys to deal with that, because the attorneys that deal with business interests might need different skills and qualifications. So some businesses will need a like-for-like attorney. So that is generally where we see multiple LPAs on property and financial affairs. However, we do sometimes see clients that have executed multiple LPAs for the same thing. Now, that's an issue because an LPA is a deed. It has to be revoked in order for the next one to then take precedence. So we have seen clients that have made multiple LPAs. They might have forgotten that they've made one, and they might have made an LPA with one person and a different one with a professional. If that is the case, the first LPA is always going to take precedence. So it's just, a lot of people don't realise that in order to make an LPA, you have to cancel the preceding one. If you make a will, there's a clause in there that cancels your will so that the new one comes into force. Not the case with powers of attorney. So it's very important, again, to make sure that clients, particularly vulnerable clients, are getting the right advice, the right type of certificate provider that can go through the steps that we've explained, to make sure the right people are being appointed and that the person does have capacity to enter into that document.
And that's all I know. Like a case example, and then we'll take questions. That's really interesting. I actually always assumed previously that LPAs were like wills and that a new LPA would automatically override an old LPA. That's brand new information for me. I guess what's becoming clear to me as well is that even if somebody wants an off-the-shelf LPA and they don't have any special things that need drafting, it can be very worth it for attorneys to, pay for an hour with yourself or someone similar just to actually properly understand all these things, because if that's new information to me,
just advise attorneys about their job.
Yeah,
yes, they might have already been appointed, but they, when they actually come to do the job, it is worth getting the advice.
Yeah, or even when you're thinking, do I want to be the attorney? Am I capable of being the attorney? Because I've seen also clients or patients in hospital particularly who just want to get out of hospital. Oh, they'll do it, they'll help. Do they know what they're taking on? Have they agreed to that? I see it more in health and welfare because there's that whole deciding on life-sustaining treatment, which people immediately flag up of, I'm not sure whether I'd be able to do that. And then sometimes that's a discussion between the donor and the attorney of whether they want that specific role or whether they actually feel like that would be too distressing for them in that kind of situation. And I think I don't get asked so many questions about the finances side because people simply don't know the scope and their fiduciary duties. Not sure if I said that correctly, but they don't know to even ask the questions in the first place.
We will often add sort of certain express powers in to the drafting. And some of it goes without saying, but some of it is making the attorney realise what they're responsible for. So sometimes you do need to add powers in, but sometimes the clients will or want things sort of explained, so that what the attorney is signing up to is very clear.
Yeah, and I think it's been very much, in my mind, from does the client understand what they're giving? And in hospital, I'd routinely do a talk for attorneys, but it didn't include things like if there's already an LPA, you actually have to revoke it first, because most people are doing their first LPA. But what if they did one 10 years ago and forgot about it?
So if they've been registered, you can do a very easy search on the OPG.
With the this bit about you have to revoke a previous LPA, does that apply to enduring powers of attorney as well?
Yeah. So this is the problem. You can do an OPG 100 to find out if a client has got an LPA in place. What if they've got an enduring power of attorney and it's not been registered? Because it doesn't have to be registered unless and until the person loses capacity. So actually that EPA would take precedence. And they're not great, are they? They're very basic.
So I'm going to finish off with an example, which I've anonymised and swapped around a few things to anonymise it further, where somebody did have capacity for LPA but not finances. So this was a gentleman whose brain injury had affected his speech, very much in terms of actually speaking, but also somewhat in terms of understanding, and also had left some visuospatial difficulties. What that meant is that he could not speak on the phone, also a video call, and his relatives could understand his speech well from knowing him, but the speech he could produce, somebody at the bank would not understand. His executive functioning was still good, but because he then also wasn't able to use a computer due to the visuospatial difficulties, and learning to use all of the things visually impaired people would have been too much to use successfully. His wife had always managed the finance side of things for them as a couple. They had that long-standing pre-existing arrangement where she managed the finances. That had his strengths had been in like DIY and managing the home and all of those things. And so they already had that arrangement. She was good with the finances. They had never had problems in the past. And he fully trusted her to do that. So you had that pre-existing arrangement already, which is important to note in many capacity decisions, is what did the person decide when they did have capacity? What was the setup they had then? I had the benefit of advice from speech and language therapy colleagues, and so they had highlighted, although his yes-no wasn't totally consistent, he was very good with pictures. So with a picture, you would think a yes-no would be the easiest thing, but if somebody can answer maybe a little bit impulsively, then yes-no isn't actually always reliable, and you can find that pictures are reliable, and the picture requires somebody to stop, think about it, and I encourage them, don't have a good look at the picture, don't just be putting it down impulsively, using the talking mats that we're going to look at this afternoon briefly. The person was able to, through some learning and using those pictures, demonstrate all of those stages that Mr. Justice Poole outlined. And I've got a various picture set that I developed with an SLT to look at those various stages. You do have to, I found, have some ability to understand written word or spoken word. You can use a total communication approach. But when you're talking about risks and is the person trustworthy, it's not that easy to, those concepts are not concrete objects that you can just like draw a picture of. So there has to be that level of understanding of risk and the use of some words within that. But with the use of talking mats, he was able to say who he wanted, or communicate who he wanted, why he wanted, what the risks were. And I do ask people about hypothetical risks, even if they're like, oh, my loved one would never do that. Okay, but what about somebody else? And if they can't demonstrate hypothetical risks, that's a worry for me for capacity. If they can say the risks of signing an LPA, all the things Senior Judge Lush worries about, The risks would be this, this and this. I don't think my loved one would do that because they're trustworthy, they're good with money, we've never had problems in the past, you know, we're married, we share all our finances anyway. Then they considered the risks and told you why they don't think they apply to them. That's fine. So with the use of talking mats, occasional spoken words that he was able to produce, pre-existing relationship with money and with his attorney, and clear guidance from the solicitor on what she would need to do in terms of what would be commingled anyway because they're married and what would need to be kept separate. Plus the fact that his personal injury settlement was not going to be 7 figures. They were looking at about £200,000 when that was done, and that was not outside the realms of what she would be managing in terms of their retirement funds anyway. So there was evidence that she would be able to manage that level of finances. They had a clear idea of what they wanted to do, what they were going to invest in, paying off the mortgage, that kind of thing, and what savings they were going to do. And so that person actually did demonstrate capacity for LPA, but did not have the capability to manage his finances by himself. One more example that's not mine, but somebody else highlighted to me. If the person can demonstrate, again, going back to the beginning, what they need help with, and say their partner is the one person that can understand their speech really well, even if everybody else struggles with it, and they make the decisions together, I always ask the question, what happens if that person is incapacitated? Because if you suddenly don't have the ability to manage your finances because your +1 isn't there anymore, then you don't have the capability of managing your finances. Putting that through someone, that would be more of the LPA side of things. That doesn't, if the scaffolding is so great that you need it, and there's recent case law on this, different topic, but a lady that was labelled Stitch instead of P because that was her preferred name after a character. She could make decisions with a lot of scaffolding in place, but then she was like, right, I've got capacity to decide to discharge myself, off I go, away from all the scaffolding, and then everything would fall apart. The judge actually said that is not capacity, that yes, we should be doing all that scaffolding, you know, the second principle of the MCA, but if you absolutely need all that scaffolding and other people have to provide it and you can't put it in place yourself, that is not longitudinal capacity.